Welcome back, future criminologists. In this video, I will be discussing Quo Warranto under Rule 66 of the Rules of Court. Quo Warranto. Quo Warranto is a Latin phrase which literally means by what authority. The special civil action of Quo Warranto is a prerogative writ by which the government can call upon any person to show by what warrant he holds a public office or exercises a public franchise. It is a proceeding or writ issued by the court to determine: first, the right to use an office, position, or franchise, and second, to oust the person holding or exercising such office, position, or franchise if his right is unfounded or if a person performed acts considered as grounds for forfeiture of said exercise of position, office, or franchise. Ang quo warranto ay isang aksyon o reklamo na maaaring isampa sa isang opisyal ng gobyerno kung hindi ito kwalipikado sa posisyon na inuupuan. When can the government commence an action for quo warranto? An action for the usurpation of a public office, position, or franchise may be commenced by a verified petition brought in the name of the Republic of the Philippines against 1. A person who usurps, intrudes into, or unlawfully holds or exercises a public office, position, or franchise. 2. A public officer who does or suffers an act which, by the provision of law, constitutes a ground for the forfeiture of his office. And 3. An association which acts as a corporation within the Philippines without being legally incorporated or without lawful authority so to act. A quo warranto is against a person, public officer, or association. Who commences an action for quo warranto? The Solicitor General or a public prosecutor, when directed by the President of the Philippines, or when upon complaint, or otherwise he has good reason to believe that a case for quo warranto can be established by proof, must commence such action. An individual also has the right to question someone's position as long as the petitioner is the one claiming authority over that position. When is an individual may commence such an action? A person claiming to be entitled to a public office or position usurped or unlawfully held or exercised by another may bring an action therefore in his own name. Hindi lahat ng individual pwedeng mag-file. Ang otorisado lang na mag-file ay ang taong nagsasabing siya ang karapat-dapat sa posisyon. Such person or individual may maintain action without the intervention of the Solicitor General. Pero kailangan niya patunayan na siya nga dapat ang nagmamay-ari sa posisyon na yon. In summary, the Solicitor General, public prosecutor, and private person may commence an action for quo warranto, subject to the conditions stated a while ago. There are two classifications of a quo warranto proceedings. First, mandatory quo warranto, and second, discretionary quo warranto. Mandatory quo warranto. It is brought by the Solicitor General or public prosecutor when directed by the President or upon complaint or when he has reason to believe that the cases for quo warranto can be established by proof. Discretionary quo warranto. It is brought by the Solicitor General or a public prosecutor at the request and upon the relation of another person, provided there must be leave of court, at the request and upon relation of another person, and indemnity bond. Where to file an action for Quo Warranto? As a rule, the Quo Warranto proceedings can be brought only in the Supreme Court, the Court of Appeals, or in the Regional Trial Court, exercising jurisdiction over the territorial area where the respondent or any of the respondents resides. The petition may be brought in the Sandigan Bayan in certain cases, but must be in aid of its appellate jurisdiction. However, when the Solicitor General commences the action, it may be brought in the Regional Trial Court in the City of Manila, in the Court of Appeals, or in the Supreme Court. So, kung si Solgen ang nag-file, ang pwede lang na RTC ay sa Manila. A Quo Warranto proceeding is one of the instances where exhaustion of administrative remedies is not required. But the rule on hierarchy of courts must still be observed. I already discussed the topic of hierarchy of courts. You can check the description box for the link. When to commence the action for Quo Warranto? As a rule, the action must be commenced within 1 year after the cause of such ouster or the right of the petitioner to hold such office or position arose. What is the effect if the action is not filed within 1 year? The failure to institute it within the reglementary period constitutes a sufficient basis for its dismissal. To whom the 1-year prescriptive period applies? When the government is the real party in interest, such as when the action was commenced by the Solicitor General and is proceeding mainly to assert its rights, there can be no defense on the ground of laches or prescription. The basic principle that prescription does not lie against the state applies in this case. The 1-year prescriptive period applies only to private individuals. There is no proprietary right over a public office. Hence, a claimed right over a public office may be waived, such as failure to question it within 1 year. Recovery of damages against the usurper of office. If the petitioner is adjudged to be entitled to the office, he may sue for damages against the alleged usurper within 1 year from entry of judgment establishing his right to the office in question. When the respondent is found guilty of usurping into, intruding into, or unlawfully holding or exercising a public office, position, or franchise, judgment shall be rendered that such respondent be ousted and altogether excluded therefrom, and that the petitioner or relator, as the case may be, recovered his cost. Such further judgment may be rendered determining the respective rights in and to the public office, position, or franchise of all the parties to the action as justice requires. Thank you for watching. If you like this video, don't forget to like and subscribe.